And then what the Supreme Court requires both in the old style.
Do they really? I haven't looked at the requirements. Have you ever briefed in the Supreme Court?
No, it's cost prohibitive. You have to have special papers that be like very narrow.
I noticed the margins are kind of strange. Yeah.
Margins are strange, and it has to be in a book that's binded, and so like you can't just email it.
Oh gosh.
You have to send like 50 copies. So. Yeah, a pretty fun non-guitar case as far as I could copy the one.
Oh yeah, I have.
Yeah.
I've had to deal with that in one case with state's appeal we actually wanted, but I don't know if it was on that issue. I think it was something else.
All rise. Hear ye, hear ye. Court of Appeals for the First District of Texas is now in session, pursuant to the Georgia Constitution and this honorable court.
Please be seated. I want to welcome everyone to the First Court of Appeals. Get my glasses out. My name is Gordon Goodman, and on my left is Justice Guerra, and you can see there's an empty seat here. The third member of our panel was Justice Ferris, who just at the first of this month was appointed to the 15th Court of Appeals. And so her place will be taken by our Chief Justice, and he'll be reviewing the proceedings on tape afterwards. But we welcome everyone here. We're looking forward to the argument. And this is for case number 0122-00776CR, styled Troy E. Hollins versus the State of Texas. And for the appellant, there's Mr. Kurt Hopke.
Present.
Thank you. And for the state, Mr. Joshua Present.
Present, Your Honor.
Okay. And there'll be 15 minutes per side. And Mr. Hopke, did you want to reserve time for rebuttal?
Yes, Judge, 5 minutes.
That'll be fine. So you'll have 10 and 5.
Yes, Judge.
Okay. Whenever you're ready, please proceed.
May it please the court. Judge, Justices, this case has a number of issues on there, and I wanted to just go ahead and jump in. I don't think I need to recite the facts, but the main issue, the first issue is the jury charge error. In this case, the application paragraph of the jury charge does not match the indictment on that was followed, and it leaves off an element of the offense, namely the owner or the owner in the theft and burglary, and it by omitting that by omitting the element of the offense, it lowers the state's burden of proof, and so that implicates the 6th and 14th Amendment for right to jury trial and for the due process. And I think in that police response, they kind of strawmanned it and said it just goes to the sufficiency, but in my analysis, it definitely goes to the right to trial and the right to due process. So, due process requires proof beyond a reasonable doubt of every fact necessary to constitute the crime charged. And so if it's an essential element of the theft or the burglary, then it's a fact that must be proven. And according to 2108, the owner is an essential element. And as it said in Uden v. State, the application is the heart and soul of the jury charge. The application paragraph specifies the factual circumstances under which the jury should convict or acquit, and that's in Uden 503 Southwest 3rd 710. And the failure to apply the law to the facts impairs the right to trial by jury guaranteed by the 6th and 14th, and that's from Ex parte Clark, 597 Southwest 2nd 760. So if We go by what's in the jury charge and the whole jury as a whole, and there's no mention of the owners there. We go by the evidence, and there was no evidence that they were the correct owners or had the greater right of possession. And even defense trial counsel's, their argument referenced the fact that they never proved that. So I think as far as the jury charge error goes, thing that the state brought up the hypothetically correct jury charge, all right? And we clearly don't have a correct jury charge here. The jury charge not only leaves off the essential element of the owners, but it also leaves off the manner and means. And under a sufficiency argument, I think I know where he's coming from, but as far as the due process and right to trial, right to jury trial, it is definitely implicated. They bring up the hypothetically correct jury charge from Moloch, and the quote is, one that is a hypothetically correct jury charge is one that accurately sets out the law, is authorized by the indictment, does not necessarily increase the state's burden of proof or necessarily restrict state's theories of liability, and adequately describes a particular offense. So what we're talking about here is the state's burden is actually being decreased, not increased. So I don't think Moloch is necessarily correct in reviewing this jury charge. Because if we're removing elements, we're decreasing the state's burden of proof. So moving on to the motion to suppress. And I invoke the unclean hands doctrine in my brief, and I think it goes to show that there's no good faith being used here, and that the state is speaking out of both sides of its mouth and using the obscured license plate as a sword and a shield. If we go over the record, you can see that the officer admits, oh yeah, I could see it, I could read it, it's translucent, I could read it. There is evidence that was submitted that it was completely legible and that there was no reason for it. He said the only reason he initially started was because when he was at a stop and a car passed by at 70, 75 miles an hour, he couldn't necessarily read it. But any normal person would have a problem with that, going by that quickly. So,
but can you go over the standard that, in terms of, I know there was evidence submitted, photographs of what the license plate looked like, and at certain distances you could see the lettering and numbers.
Right.
But can you talk about, the standard here is whether the officer had, reason to believe that an offense was being committed.
Right. And so, yeah, it has to be obscured under give me a second, Judge. So it has to be obscured by some kind of coating or anything like that that in some way impairs your ability to actually read it. The officer testified that it needs to be visible up to 50 feet, but that's not in the actual statute. So the issue is that the officer claims that it was unreadable at the time of the stop, but admits on the scene, yeah, he could read it. And then we also have the other issue of the license plate cams that the state uses to track the defendant's location. And so those are visible on those cams. It's visible when he's, after he stops, realize, oh yeah, it's there, I can read it. And it's translucent, there's not an issue. He admits it. So the issue is it goes to his credibility, and also goes to the credibility of the judge and whether or not, this is even believable. And I think under that standard, it is talking about both at both sides of his mouth. And so the next issue is in regard to the GPS tracking under Daubert. And there's very specific rules in Daubert and Kelly. The theory has to be valid, technique has to be valid, and has to be properly applied. and be, the qualifications, reliability, and the relevance. And there's no valid technique that's being used here. I mean, there's no valid science that the expert was able to explain. There was no technique applied, and there was no way of knowing whether or not it was applied. There was also, the officer, Mahoney, couldn't tell you the radiuses of the coverage areas. He couldn't tell you if the targets were in those radiuses. He couldn't tell you if the phone connected to that one or to another one that had a stronger signal. It was all guesswork, and guesswork is not expert work. He had no literature that backed up his claim. He had couldn't describe a rate of error. He couldn't talk about any availability of other experts. There was no clarity to what he testified because he couldn't know which one it was if it actually included those targets.
Do you have any case law that where this issue has been raised that holds that this is not a valid expert topic?
There is no case law that I saw about that particular issue, but it is relying on the principles of Daubert and Kelly, and that there are certain requirements that need to be met, and they were not met. Again, moving on to the identity issue under the sufficiency of the evidence, no eyewitnesses, no witness, accomplice testimony, no fingerprints, no forensics, nothing that points to my client being at the original Creekside, and then certainly nothing at the target. There's no evidence that he was ever actually inside of any of these targets. The only thing they have is that he was wearing underwear that obviously is not necessarily special. So I think under the sufficiency of the evidence, there's very little that actually connects him to this other than he was wearing the same underwear at the time of the stop as what they saw in the still photo at the movie theater. There's no surveillance at the target or anything like that that shows the same.
So, in your brief, you argued that the evidence was factually insufficient
Yes,
to
Judge.
support the verdict and the judgment in this case. But I'm sure, as you know, the
Yeah.
Court of Criminal Appeals has said that we don't do factual sufficiency, and instead we do a legal sufficiency challenge.
Right.
So, what's your best argument for why we should be entertaining that challenge?
Oh, because under the sufficiency of the evidence, it's not there. There is not enough to connect Mr. Hollins to these things. And I think a lot of times I try to practice law the way I want the law to be versus the way it is sometimes, and that sometimes gets in the way of writing these briefs. But under the sufficiency of the evidence, I don't think that they reach their burden to show that there is a nexus between Mr. Hollins, his identity, and these robbers. And I'll reserve the rest of my time.
Very good. Thank you, Mr. Hopkey, and we'll add 2 minutes to the time for Mr. President.
Thank you, Your Honor.
May it please the court, counsel. I plan to go through a brief recitation of some of the important facts before following the grounds addressed in the brief in approximately that order. I'll also mention some of the citations in our letter of additional authorities filed yesterday, which I hope you'll have a copy of. I have additional copies. This case involves engaging in organized criminal activity with underlying theft offenses. There was testimony from investigators related to the Bloods gang at issue, which appellant self-identified with, that they would frequently travel long distances, often at night, down the highway, sometimes hundreds of miles, commit thefts in various stores, and then travel back up the highway to their home base in Dallas. That was their modus operandi. That was actually found to be the case in this particular case. Cell phone evidence from appellant indicates that he would leave Dallas sometimes middle of the night, maybe after midnight, travel hundreds of miles to Houston or San Antonio with his crew. They would break into typically Target's stores, open up the ATMs, get the cash, and get out. It was very quick. They were very experienced. The investigators noted that normally people would take maybe up to 30 minutes, but they were in and out in a few minutes. They had a similar modus operandi in each case. They would use similar tools, often yellow crowbars. They would wear long black clothing to try to conceal tattoos and things of that nature. But there were some slip-ups. Appellant wore some distinctive boxers, which were on the Cinemark burglary on the surveillance video, and they were also, he was wearing them as they acknowledged at the traffic stop. Also, there was a very distinctive sweater that investigators had difficulty finding, but it was both in several of the videos and it was in the vehicle when the appellant was later stopped. So we argued basically the doctrine of chances in our brief, among several other things, showing that investigators noted that if you have this one incident one time, where coincidentally he leaves the area of Dallas, drives hundreds of miles, and coincidentally happens to be around the area of the target burglary, and then goes straight back to Dallas, that's already a big coincidence. But when you're talking about this case, that happened 6 times. The other thing that was interesting when they stopped the car.
May I ask a question
yes.
about the number of times? Isn't it true that there was no, you're talking about the cell phone data connecting him to the different locations?
Yes, Your Honor.
And is it true that there was one location where he wasn't actually, there wasn't the cell phone data from his phone that was detected?
That's a good question, Your Honor. I think you're talking about the Hearst burglary, and I think if you look at the totality of the evidence, including all the other burglaries, I think there's actually sufficient evidence regarding that particular offense, because you still have him leaving the Dallas area where his home is and going to an area nearby the Hearst target. And investigators explained this was apparently their practice. They would go to one target, and if it appeared too many people were there, too many employees, they didn't want to do it with people around, so they would go to a nearby target. So his cell phone data did appear at the target near the Hearst target about 3 a.m. And then didn't have any more data points. Apparently sometimes, like if you're not using the cell phone, it may not connect to a tower. But I think it still showed that he was leaving Dallas and came to a target nearby the Hearst target. So 3 a.m. in the morning, for whatever reason, and I think you view the combined and cumulative force of the evidence in the light most favorable to the verdict, considering all these other times where he just happens to leave Dallas and show up nearby these other burglaries. I think there's legally sufficient evidence even to connect him to that particular offense. But yes, there was a gap in time between 3 and 4 a.m. Where he was nearby the Hearst, but they didn't have any data points where he was actually at the Hearst. There is, that kind of ties into a sufficiency argument in ground 5, where he says he's not adequately connected to all the offenses. There was actually in the letter of additional authorities a case called Jarnigan, it was in the footnote, where there was a similar sufficiency claim made where the appellant, who was an attorney, said that, well, the state might have proven my association with maybe $70,000 worth, but not with these other offenses. That wasn't enough, according to him. The Court of Appeals rejected that. They noted that there was a party liability theory in there, so that even if the attorney did not appear and represent on those other cases as the principal, he's still liable under party liability. The jury could apparently infer that as a party, he was still responsible for that act. So I think, likewise in this case, I think there is legally sufficient evidence, given the fact that he departed Dallas and appeared at the target nearby. But that's under the principal theory. Even under party liability, I think he aided, encouraged, or attempted to aid when you view the combined and cumulative force of the evidence in the light most favorable to the verdict. So the first ground, he claims there was a jury charge error. The letter of additional authorities, there's actually multiple bases to reject that ground. The letter of additional authorities points out that when you're dealing with an engaging offense like this, the elements of the theft offense are not actually essential elements of the offense. In fact, this court, in one of the cases, noted that the name of the owner was not even required. It was inconsequential or something of that nature. I think they used a phrase similar to that. But it's considered a manner and means. And when you're dealing with manner and means, there's actually case law that says the hypothetically correct jury charge does not incorporate manner and means. And the case that I did not give y'all yet is Thomas. It's 303 Southwest 3rd, 331. But that was one basis to reject the claim. The other has been mentioned in the state's brief is the hypothetically correct jury charge. He keeps analyzing it under the jury charge actually given, but they expressly refuted that in CCA case law. You have to go according to the hypothetically correct jury charge, which actually the indictment did include the names. When you evaluate the evidence, the sufficiency of the evidence according to the hypothetically correct jury charge, it was sufficient and met all the essential elements. There was even evidence regarding the owners or special owners alleged in the indictment. There was evidence that the target individual, for example, had a greater right of possession, which is interpreted very broadly. There was evidence they had a leasing agreement with the ATM machine that was obviously physically located within the target buildings. They had physical possession of it, and they had a leasing agreement with the ATM owner. So they had a greater right of possession as compared to appellant who had absolutely no right of possession. There was another case that I thought was interesting in that regard that might be helpful. I cited several others. It's James B. State, 2003, Tex App Lexus, 5799 out of Dallas in 2003. That one was an auction manager, and it was interesting. They said that he had a greater right of possession than his employee, the appellant in that case. It was a car that was consigned to auction that the appellant stole, and they basically said even though it was consigned, it's not typical ownership that we would think of. He was still considered to have a greater right of possession as the auction manager than the appellant who was his employee in that case. In our case, they had a greater right of possession, obviously, than the defendant who had absolutely no right of possession.
Okay, I'm going to divert us back to the theory, the expert issue, and the reliability of this method. I don't think you had a case either necessarily on point on this method of tracing. So I wanted to know if you found another case, or what's your strongest case for that?
So we actually have two different arguments on that one. In the letter of additional authority, we cited several cases where they recognize that this type of evidence the scientific theory behind it has been accepted in courts for over a quarter of a century. There's actually one that mentions the exact type of software used in this case where the court found it was reliable enough. But in this case, there was actually some testimony from Mahoney. I mean, it could have been clearer, but they did ask him, are you aware of any peer-reviewed scholarly articles? He said yes, they just didn't know the names. They also asked him, I think the defense asked him, are you aware of any scientific body that has reviewed this? And he said, again, I don't know their names. Now, there's two things you can take from that. Either, if you want, and this is something that comes up frequently in defendant's arguments, he wants to view the evidence in the light most favorable to the defendant, but that's the exact opposite of the correct standard of review. The judge could have looked at what Mahoney said and said, okay, there are articles, he just doesn't know the names. Or he could have looked at it and said, well, he doesn't know the names, there are no articles. We know what the judge did, he let the evidence in. So we have to defer to the judge's view, which was, there were scholarly articles, even if Mahoney didn't know what the names were. So if you look at those cases we cited in our letter of additional authorities, there are several that recognize this science is reliable. But even if we didn't have that at all, I like the case that we cited in our brief, Aaliyah v. State, which is unpublished technically, and I might want to mention that defense attorneys will frequently say, oh, it's unpublished, just ignore it. But this court is well aware that even unpublished opinions have to follow the law. And to the extent the law and the standard of review dictated the result in that unpublished case, the court may not be bound by the opinion per se, but I think it is bound by the law to reach the correct result, which they reached in Aaliyah. Aaliyah also cited this in published cases. They noted that when you're dealing with reliability, it's a flexible inquiry. So sometimes you're going to have scholarly articles, sometimes you're going to deal with experience. And in the Aaliyah case, it was actually remarkably similar to this case. The investigator testified to the cell phone location general areas. She was cross-examined on the fact that there was, I believe they said 90% in that case as well, which is the same in ours. Mahoney said there was 90% or more accurate in our case. But in that case, in Aaliyah, they noted that there was actually a corroborating evidence independent of the cell phone evidence. There was surveillance video which apparently showed the defendant at the same location where the cell phone evidence did. Our case is remarkably similar to that. Mahoney did testify to prior instances where this science has proved reliable. He had located personally a body in another case. He also, I think, referenced a case that he wasn't personally involved in, but it was a body found in the desert based on the same evidence. The other interesting thing was, not only was it scientifically reliable generally, but the method was properly applied in this case and proved to be reliable in this case, based on corroboration in this case. There were 4 instances. So one time, as Mahoney said, there was an instance where the cell phone evidence said he was in a certain location and the license plate reader showed he was in that same location. There was an instance where Mahoney said the cell phone evidence indicated he was near a particular gas station and appellant was on the surveillance video of the gas station. Those matched up. There was also the instance with the Trooper Royal stop. Cell phone evidence said he was there. Obviously, he's on Trooper Royal's video. The last one is at the Creekside. He said the cell phone evidence indicated he was near the Creekside at the time of the burglary, and the appellant is on the Creekside burglary video with his distinctive boxer shorts. So you have 4 instances where the evidence was corroborated in this case as being reliable in this case. That deals with 1 and 3. That's Mahoney's testimony. I would also note the trial court recognized and made some other interesting observations, which I cited several in the letter of additional authorities. He noted that this is very common technology. In fact, Carpenter noted this is basically widespread. This is the way life is now. Everyone is aware that their cell phones can track them. This was created by multi-billion-dollar corporations and is used with 300 million people across the country, and in order to improve their business function and model. And the interesting thing that the trial court said was, he noted this is such common knowledge that even criminals, layperson criminals, will sometimes use burner cell phones to try to avoid disclosing their location because they know it's reliable and damning evidence that will hurt them at trial. So that addresses grounds 3 and 1. Briefly on the motion to suppress, the trial court already pointed this out, the Honorable Court of Appeals already pointed this out. The correct standard of review is not factual sufficiency. He not only cites factual sufficiency, he frequently throughout his brief in different contexts will cite to particular evidence, viewing it in the light most favorable to the defendant, which is the exact opposite. It's even beyond factual sufficiency. The court has to look at the combined and cumulative force of the evidence in the light most favorable to the trial court's rulings and to the jury's verdict. One of the examples of that is in the motion to suppress. He likes to cite evidence of this license plate reader and the picture that's only a couple feet away from the back of the car. The problem is, Trooper Royal testified, and he said, I was on the side of the road, I saw other vehicles pass by, I think he indicated that he could see the other vehicle's license plate, but he could not see defendants at that angle. And if you read the actual language of the statute, Texas Transportation Code 504-945, he actually violated multiple provisions, and again, we don't have to prove a violation, but there was reasonable suspicion of a violation. He violated one provision where it said it obscures, significantly impairs the readability of the license plate, and it's, quote, at any time. So it's not, oh, it's clear here 2 feet behind, it's at any time. And he was on the side of the road, he testified, it was blurred, I couldn't see it. The trial court denied the motion to suppress, the trial court believed him. So we have a few of the evidence we have to defer to, which is the trial court's. And by the way, there was a 38.23 instruction, and the jury also rejected this argument. The other part of 945 to look at is, there's a later provision that says, or a covering that distorts angular visibility. So it's not talking about 2 feet behind or a cell phone or a license plate reader. It's talking about, in this case, standing on the side of the road and seeing cars pass by. The angular visibility is distorted by that license plate, by the light refraction or whatever else. This is a common theme, as I said. I think if the court looks at the evidence not in the light most favorable to the defendant, as he frequently argues, but in the light most favorable to the trial court's ruling and the jury's verdict, I think it will help with the rejection of all these points of error. Getting back to the sufficiency of the evidence, I think I've already reviewed, I think the evidence, when you view the combined and cumulative force of the evidence, all these, it would be absurd to say, I mean, it's hard enough to believe that he just coincidentally left Dallas and then coincidentally was right next to this Houston burglary and then went right back to, that's hard enough. But he did it 6 times or 5.5 if you want to say that he was near the Hearst burglary. I think there was legally sufficient evidence for the Hearst burglary, but for whatever reason, if you want to say, let's just throw the Hearst burglary out. The state actually noted at trial in closing arguments, I believe, that if you threw the Hearst burglary amount out, it was $30,000, you would still exceed the threshold of $150,000. I believe it would be over $170,000, just ignoring the Hearst burglary entirely, which I don't think you have to do. Again, relying in part on that case in the letter of additional authorities where they dismissed his argument that he wasn't involved in all of them based on the theory of party liability. He aided, encouraged, or attempted to aid. And I think you can see the scheme when you look at the combined and cumulative force of the evidence, because this happened 5 or 6 times. The other thing that he tries to say, he says there's insufficient evidence of identity. Again, viewing the combined and cumulative force of the evidence in light most favorable to the verdict. I think it would be difficult for a jury to find this was all just one massive coincidence. That's what the doctrine of chances is for. In addition to the fact that you had his underwear in the Creekside robbery. It was stopped hours later, it was still wearing it. The other thing that's interesting that I think is helpful for identity, really just sufficiency in general, when he was stopped by Trooper Royal, they found, I mean, obviously not only was he still wearing the boxers that he was on the robbery video on, or sorry, the burglary video on, they found wads of small bills on multiple individuals, including appellant. They gave different explanations for where those bills came from. They had the yellow tools, including the crowbars, which had been used to pry open the Cinemark doors. There were still yellow paint transfer markings on the Cinemark doors. They lied about the purpose for those tools. He said, oh, it's for concrete work at my grandma's. The trooper himself had actually done a lot of concrete work, and he recognized these things would be filthy if there was concrete work. They're clean as a whistle. He's lying. Lying indicates consciousness of guilt. It is one of the strongest kinds of evidence of guilt, especially in cases where frequently you're not going to have a confession, but there is case law from the Third Court, the CCA, where they recognize that lying about something like this demonstrates basically consciousness of guilt, and there are a few things that are more compelling than that. And you don't have that by itself. You have, as I've said, all the other cell phone evidence. To the extent they try to argue, I don't know that he will, that you should exclude the cell phone evidence or certain pieces of evidence because they were allegedly improperly admitted. They were properly admitted, but for the sake of argument, even if you were to say, oh, maybe those were improperly admitted, the sufficiency analysis takes everything into consideration, properly and improperly admitted evidence. One of the errors courts of appeals sometimes fall into is they look at ways the evidence could have been stronger or things they wish were in evidence, and they've been reversed for that by the Court of Criminal Appeals on multiple occasions. I see my time is up. If I can just briefly say, if the Court of Appeals looks at everything in the light most favorable to the verdict and the trial court's rulings, I think you'll easily dismiss all of these points of error. Thank you for your time.
Thank you, Mr. President. So, Mr. Hopke, you have 5 minutes.
Okay. One thing that really stood out to me in his argument is about how he would be culpable under the law of parties, even if we can't specifically put him inside any particular place or the Creekside Cinema or the Target or anything like that. But all they have for that identity and that he was actually there is underwear that is, like he said about the cell phones, mass-produced. We talked about, there's evidence in the record of the tools that were distinctive. Well, they never dusted them for prints because those are mass-produced and wouldn't prove anything. There's nothing special about the underwear. There's nothing special about the tools. There's nothing special about these dollar bills. And there was no evidence actually putting him inside there. But if we go into the law of parties, okay, well, maybe someone else is in there and he aided, encouraged, solicited, was an active participant. But there's no, if you look through the whole record, there is no evidence of that at all. And so all we're left with is mere presence, and mere presence is, of course, not enough to convict. And so under the legal sufficiency thing, we go there. And then we have to remember that under this cell phone data on the record, Mr. Officer Mahoney, said, well, I don't know, I can't calculate the range of the radius. We can't determine if these targets are actually in this radius. So they're talking about all this stuff about everything being, oh, evidence shows them here, evidence shows them here. We don't know that because the expert was not qualified. He had no technology, no technique, no scientific theory, and had no reliability. And so all of these things were improperly admitted by allowing him to testify to this. And so the trial court should have realized that and applied the standards of Daubert and Kelly and everything else to determine that, well, if this stuff isn't reliable and he can't tell me, yes, he was here or not, then there's a problem with going into any of that evidence. And regarding the jury charge error, he talks about the manner and means and things like that, but none of that addresses the constitutional issues under the 6th and 14th and 5th in regards to the damage, the harm, that is the egregious harm that's actually being done. Those are constitutional amendments that protect each and every one of us. But if they are allowed to lower the state's burden by submitting a jury charge that does not have an essential element on it, then it makes the jury's job easier to convict because there's one less thing they have to consider. And if we're talking about, sufficiency of the evidence, but we're also talking about constitutional amendments that have to be considered and that each of us has. So if you reduce the state's burden, you are harming egregiously the defendant. They talk about the distinctive boxers, distinctive sweaters. Those are all mass-produced. The tools, mass-produced. As regards to the motion to suppress, the judge has to choose whether or not a reasonable person would be able to determine if this was readable or not readable. All right, and we have ample evidence that it was readable. And it strains credulity, and it invokes the unclean hands doctrine that they're not following, it's not reasonable for him to think that it was unreadable when it was. He said, there's no literature, there's no scientific bodies. They're bringing up the, other cases where it was brought up, but that's not part of the record that was in here. If that's not in the record, then there is no scientific basis. There is no literature that backs it up. There is nothing in the evidence that shows any of that. So, but they want, he can't tell you the radiuses, he can't tell you that he was even in the target or even in the vicinity because he doesn't know, because the cell phone tower could have been connected anywhere. And we don't know the coverage area, and we don't know that. And so all of that goes. And I don't think, he's talking about the Hearst target, but I think all the targets are in question because there is no surveillance, there is no DNA, there is no testimony that he was ever in those. And so I think if you remove all of those, we don't reach a first degree. I think we only end up in a state jail situation. And so Johnson v. State, which I have the site somewhere, but I can submit it later, says that if there is an issue with the jury charge and there's an issue with whether or not it's sufficient to charge on the escalator, Johnson v. State said that this Court of Appeals could reduce this to the appropriate punishment range and remand to the court there. And so we request, appellant requests relief, request that this court reverse and remand this case for acquittal or any other solution that justice serves. And so I would ask that if not for acquittal, then to reduce it to the state jail felony. Thank you.
Thank you.
Thank you, Mr. Hoppe. The case of Troy Hollins versus the state of Texas, number 0122007776CR, has now been submitted. And I want to thank both counsel for their arguments.
Thank you, Your Honor.
Court is adjourned.
Thank you.
All rise.